Hi, so I wanted to talk a bit about the High Court and Supreme Court ruling regarding Article 50. It's called the 2016 Miller and Dos Santos versus Secretary of State for Exiting the European Union. And in short, this was a case that states that the UK government can't use the royal prerogative to trigger Article 50. Instead, it requires an act of Parliament and debate within the House of Commons and Lords. Now, I find this concerning on a larger scale, a broader picture. I myself am a Brexiter, but I do think that Leave and Remainers should find this concerning equally, and I'll explain why that is in a bit. To give you a bit of background here, the person who brought this case to the courts was Gina Miller. She's originally from Guyana, a South American country beside Venezuela. She was previously an attorney general there, but she came over to Britain. She started working with a few companies, and she ended up founding a company called the SCM Direct, and that was with her. It was co-founded with her husband Alan Miller. She's also founded an organisation called the True and Fair Foundation, and basically it's to create a bit of ethics within the pensions and investment industry, where hidden fees and charges and costs and managers and stuff like this were taking money from people's investments and basically keeping it for themselves. The funny thing is, Alan Miller actually made his money that way. That is how he got rich. He was in this industry and taking people's money illegitimately. Well, not illegitimately, but like I say, hidden fees, which is not illegal but unethical. For example, in 2012, Merrin Webb wrote an article for MoneyWeek called Turncoat Fund Manager. Basically, she said in this that the fund management industry isn't really keen on the Millers. It's kind of a poacher turned gamekeeper sort of scenario. For example, he made 30 million during his time as chief investment officer at New Star. And like I said, he's confessed to using these unethical tactics to earn his millions, really. And now it seems as though he's reformed, and now he's working in an organisation with his wife that seeks to end this unethical practice within the fund management industry. But what I find strange about this is that it's kind of redundant, since the RDR, which is the Retail Distribution Review, basically reformed the industry, and it kind of acts as a bit of a judicial review body regulating financial services industry. This was started on 31st of December 2012. So it just seems that this, I don't know, charity, I guess, is kind of redundant. There's already a law body there that reviews and regulates the industry, as it were. What I really wanted to drive at with this was that obviously the Millers have a bit of a background with these shady tactics, I would say, within the industry. So they do know the ins and outs of law and how to manipulate and twist things like this here. And this is really, really important when we start talking about this case. So of course, as I said, the case is called 2016 Miller and Dos Santos versus Secretary of State for Exiting the European Union. So it really says that the UK government, the executive, which would be obviously the Conservative Party at the minute, led by Theresa May, cannot use the royal prerogative to trigger Article 50. Instead, they need to debate and have an act of Parliament. So considering that this was a referendum, that the people, had a vote and we voted to leave, now we're being told, well, that can't do it alone. It has to be done through Parliament. Gina Miller claims that that allowing the government to use the royal prerogative to initiate to trigger Article 50 would give the government untold powers. Like, she literally says it would just allow them to take away people's rights. In fact, she even said it would set us back 400 years, which is absolute insanity. I mean, she's doomsdaying what the royal prerogative would do in this case. The royal prerogative would simply be used to enact a referendum which the people voted on. And the fact that she seems to think this will take away people's rights is absolutely insane. In fact, I argue the complete and utter opposite. I say you're taking away people's rights by saying that a referendum is not binding. If you say that a referendum is not binding, then basically a referendum becomes a glorified opinion poll. It's not actually a piece of legislation, it's just a glorified opinion poll. So I make the argument that you're actually taking away people's rights by saying that you need an act of parliament in order to initiate a referendum. And this is what I'm talking about. This is something that Leavers and Remainers should both be worried about. Because I'm going to talk a wee bit more about this in a second. I'm going to carry on with what happened. But I'm basically trying to make the argument that if we the people don't have anything binding, if we don't have something that the government has to do when we vote on it directly, then we don't really have any say legislatively. And I think there should be something there. But I'll carry on here about what's really happened. She claims that this is all about parliamentary sovereignty, and this is where she said that, Nigel Farage should be her biggest fan and this, that and the other. What I really see is that by making the government, the legislator, vote on this, and basically saying that the referendum itself isn't binding, this gives the MPs who were Remainers, this basically gives them an opportunity to create amendments and to weaken what Brexit really is. Like, this will give them a chance to vote in the single market, and whether or not the High Court in London will or whether we will have judicial control basically instead of the EU. There's lots of amendments and bits and pieces that can go onto the white papers, it's called. But to me, this was done. She claims it's not political, but I claim it is. I think this was done in order to weaken Brexit, basically. So basically what happened is the High Court ruled 8-3 in favour of Miller, saying that this needs to be this needs to go through the House of Commons and House of Lords. I think the reasoning was something along the lines of previous referendums had an act of parliament, so to me that just seems more like a formality rather than legal proceedings. But obviously the High Court didn't agree, and they said no, this has to, you need an act of parliament here. Again, that just basically says that referendums are not binding, which I find quite concerning. It was then appealed by the government and was brought to the Supreme Court, and the Supreme Court just basically agreed with the same previous ruling on it. So Parliament were then forced to vote on the issue, and despite the fact that Brexit actually won and that the Parliament voted in favour 498 to 114, so we had a massive majority in favour of triggering Article 50. I still don't like the ruling on this. I still don't like the idea that a referendum is non-binding, and if referendums aren't binding, then I'm left with the question: should we reform referendums? Or should we be pushing for a piece of legislation to make sure that referendums are binding in the future? Or should we have a new system in place, something that says if the people vote on a given piece of legislation, then it is binding to the people's choice, and that it does not require any act of parliament. It can be used via the royal prerogative, and that just basically says that if the people vote on something, it's binding. And the thing is, this can come back to bite Remainers at some point. Let's say, for example, right, years down the line, Brexit doesn't work out, and we maybe have another referendum to say, to leave, right? And maybe it ends up working in Remainers' favour. But because it's non-binding, maybe the government doesn't want to. Maybe it won't leave. Maybe it thinks we're not going to get a good deal by going back into the EU because the EU, is myth that we left in the first place or something. I don't know. I'm just spitballing there, but you know what I mean. It could be anything. The fact that a referendum is non-binding, that's concerning to me. I'm just personally worried about it. So that's what I'm asking the question. What is a referendum now? What does a referendum mean? It's a glorified opinion poll. Isn't that what it is? It's basically a glorified opinion poll. So I think we either need to reform what referendums are, put in a piece of legislation that says, listen, if the public votes on a piece of legislation and they vote, well, either way, in favour or not in favour, that has to be enacted, that royal prerogative powers can be used to initiate the people's will. So that this will bypass the Act of Parliament. I think that's important. I think that's a really important democratic move. But feel free to say what you think in the comments below. That's my view on it. I think it's important. Maybe someone else disagrees, but be sure to leave a thought in the comment below. Thank you.